It's so nice to see all of you here on this webinar today, brought to you by our Master of Legal Studies in Cybersecurity and Data Privacy at CSU College of Law. Our topic today is cybersecurity litigation, lessons from the nation's leading privacy litigator, Doug Meal, who you'll hear from more later. But first, I want to introduce myself and Brian Ray, who work very closely with the Master of Legal Studies program. So many of you I may have already spoken to or you've received emails from me, but my name is Julie DiBiasio and I'm the director of the program and here to help you throughout the whole admissions process and any questions that you have. And Brian Ray, he directs our Center for Cybersecurity and Privacy Protection. He also co-founded the center at CSU College of Law, and he also teaches within our cybersecurity program. So you are very lucky to have him as a faculty member within that program. Brian is going to do a formal introduction of our special guest, Doug Meal, again, who we are very happy to hear from and have here today. Just a quick agenda. We're going to start with the conversation with Doug. And if time permits, we'll do a program overview, go over the application, and of course, a Q&A. However, I do like to mention that at any time throughout Brian and Doug's conversation, please feel free to put any questions in the chat. We like to make this very informal and we can have more of a conversation that way. So I'm actually going to stop sharing my screen so you and Doug can have a great conversation. And Brian, I'm going to toss it over to you to formally introduce our special guest, Doug Meal.
Thanks, Julie, and welcome everybody, both those of you here live and watching the video. As Julie said, for those of you who are attending, feel free to send questions in the chat at any time, and we'd love to answer those questions. As Julie said, really excited to have Doug Meal here. Doug and I have known each other really since the inception of the center, and have done a lot of work together as part of a national legal think tank, legal law and technology think tank, the Sedona conference. I was introduced to Doug at the first Sedona conference working group 11, which is the data privacy cybersecurity working group. I was looking for speakers for our very first center conference, and several people said, well, you got to talk to Doug. And he was either described, I can never remember the precise language, it was either as the dean or the don of cybersecurity litigation. So slightly different valences there, but either way, literally the top guy in cybersecurity class actions, regulatory investigations. So Doug might not remember this, but I made a point of on Saturday morning finding him at the breakfast table and then saying, hey, we got a conference coming up. Any interest? And happily Doug came, and we've been doing a lot of work together since. But Doug has a really impressive background. I'm not going to read through it, but he really came into this work at the inception of many things, including cybersecurity class action litigations, and really has helped shape the field. And so evidence of that is Chambers USA named him as the first ever Band 1 litigator, and Chambers is one of these national international groups that surveys attorneys in particular practice areas to figure out who are the top folks. So the first ever Band 1 litigator in privacy and data security, and described him as, quote, being regarded by market sources as the leading privacy litigator in the USA. Oh, I'm sorry, and this is where the quote came from. I missed this. The dean of the data privacy litigation bar. So he has litigated several landmark cases, including the only case to successfully challenge the Federal Trade Commission's authority under their operative statute to do certain kinds of things with respect to cybersecurity, the LabMD case. And so when Doug came to me, was retiring from, I don't know if it's appropriate to say, from let's say from large law firm practice, because Doug continues to serve as an arbitrator and is doing many things in the field, and said he'd be interested in teaching, I immediately said, yes, absolutely, let's do it. What do you want to teach? And so Doug teaches for us cybersecurity litigation, which obviously draws on his deep experience and is a really interesting class. So we'll get to that class here in just a minute. But before we do that, I wanted to get a little bit about Doug's background out on the table, and also his perspective on the field, because he really has seen it emerge and develop over time. And so Doug, with that, when did you first start working on cybersecurity data privacy issues, and what were you doing before that?
Well, first of all, Brian, thanks so much for having me. And for those who are watching either live or on recording, thanks for joining us. So I first got involved in this area in 2006. In fact, I still remember the day. It was December 13, 2006. My background prior to that had been that I was what I would call a general commercial litigator. I didn't specialize in any sort of substantive area of the law. I specialized in being a trial lawyer. Uh, and uh, and in the course of doing that, I had developed a long-standing relationship with the TJX companies. They operate TJ Maxx and Marshalls, Home Goods, brands like that. And I'd done all kinds of litigation for them for years, in sort of, important kind of bet the company-ish type litigation. Anyway, on December 13, 2006, the general counsel of TJX called me up and said, Doug, I think we have a problem. We think someone has stolen a whole bunch of credit card information from our network. And I sort of paused and said, well, not sure why you're calling me. Maybe you want to call the police or something like that. And she said, well, the reason I'm calling you is that we're worried that someone may claim that we're at fault in terms of this having happened and blame us for this. And I'm there like, well, that's impossible. That's insane. You're the victim of a criminal event here. How can anyone possibly blame you for the fact that this theft has occurred? Which shows you, number one, that I knew nothing about cybersecurity or cybersecurity law or privacy law at the time, and also shows you that really there wasn't any such thing much
Yeah.
called cybersecurity law at the time. Anyway, notwithstanding that very inauspicious job interview that I gave in regard to this particular matter, TJ hired my firm. I was at Ropes and Gray at the time. Hired my firm to handle this data breach, and I wound up being the lead of the Ropes and Gray team, which had a massive team that handled the data breach on behalf of TJX, and and it turned out to be the largest data breach in history at the time. And in fact, even to this day, it is still the largest retailer credit card breach that ever happened. Larger, for example, than the more notorious Home Depot and Target breaches that occurred in the ensuing decade. And so it had everything. It had all kinds of regulatory investigations. It had all kinds of class actions. Uh, and uh, and so we learned in the course of doing this, the entire field, such as it was at the time, of cybersecurity litigation, both from a regulatory enforcement perspective and a class action perspective. Anyway, and we worked on it for 2 years, basically nonstop. It was insane. Anyway, at the end of it, Ropes and Gray management came to me and said, "Hey, Doug, this, this could be a great opportunity for us. You and we have gotten all this experience in handling matters like this. What if we and what if you try to develop this as a practice area?" And I'm there like, are you nuts? Do I have to remind you that this was the mother of all data breaches? Do you seriously think this is ever going to occur again? This was great. We made a lot of money. We got some great results for TJX, but it's a one-trick pony. This is never going to happen again. So no way am I wasting my precious time doing this. Well, this illustrates why I was never a part of firm management at Ropes and Gray, because the powers that be sort of patted me on the head and said, well, we'd like you to give it a shot nonetheless. And I did my imitation of my teenage daughter with an eye roll and said, all right, if you say so. And of course, I was totally wrong, and the firm was totally right. And data breaches kept happening on a large scale, as everyone here knows. And because we had developed, a little reputation for ourselves in this very narrow field that no one else at the time was occupying, we kept getting called to come in and help companies that suffered ensuing data breaches, including, for example, the Target and Home Depot breaches that I mentioned earlier. So I completely blundered into this area, but in the last sort of 15 years or so, or 20 years almost, my career in private practice, defending companies that suffered major cybersecurity and privacy events against regulatory investigations and class action litigation coming out of those events became my almost my exclusive area of focus. So I went from being a generalist to a specialist practically overnight on December 13 of 2006, which is why that date is etched in my memory, as well as the general counsel of TJX's memory. No one else's memory, but certainly in mine.
Also 2 weeks before Christmas, and it consumed your life, right? So,
yes, absolutely.
So just to flesh that out a little bit, because I'm fascinated. I mean, I talked to you a little bit about this. We've never gone deep, and we don't have time to go real deep. But at that point in time, I mean, was there obviously no or not many law firms that had quote unquote incident response teams. On the forensic side, had the technical stuff developed, or did you guys have to kind of figure it out and find technical groups to come in and work through what they needed to identify and everything else?
It was, for example, on the forensic side, it was just getting off the ground. There were like 3 companies. I mean, of course, today there's
Right.
To say dozens is an understatement, right? I mean,
Exactly.
Hundreds
Yeah.
of forensic firms that offer incident response services and post-breach forensics and things like that. There were sort of 3 firms that were leaders in the area. So that was just getting started. And from a lawyer perspective, no, there was no one like the sort of lawyer that I became. No one who held himself or herself out as a specialist in these kind of matters, because you couldn't. There had been a couple of reasonably significant data breaches in the 2002 to 2006 timeframe, but they weren't occurring at a rate that anybody could have remotely thought that they were going to specialize in handling these things. So I mean, in that way, I was incredibly lucky. If that breach had happened 10 years later, after many lawyers had occupied the field, there was no way that TJ would have hired somebody who had 0 experience doing these cases. So that changed very dramatically. But at the time, it was essentially a virgin territory, both forensically and legally, and there was very little case law, minuscule amount of case law in the area on what would be the crucial issues in regard to cybersecurity liability and privacy liability.
And so the plaintiff's side, we're just being very entrepreneurial in saying, hey, there's got to be damages here. There's got to be a theory of a cause of action in terms of these class action.
Yeah, I mean, it's been an interesting thing to watch as you see kind of the push and pull between the plaintiff side and the defendant side, where the plaintiff side will come up with a theory of either liability or injury. The defense side will then figure out a way to counter that. The plaintiff side, undeterred, then comes up with a more sophisticated, let's call it, or more offbeat theory. Defendant side will work on counteracting that. The cases keep getting filed over and over and over again. And so the basic themes have remained the same, but the theories of liability in regard to those themes have developed significantly, and the theories of injury in regard to those themes have developed significantly over the years, definitely. And that's been sort of interesting for me because I find the field very interesting to watch.
Yeah. Yeah, and I remember when I was first getting in, we brought in the Chris Dorff and the Olson firm, and they were pioneering the notion of essentially warranty for a padlock, right? Like that security was an implicit part of a contract to get around the concerns of standing and injury and the tort claims that we're developing. On the regulatory side, I mean, at this point in time, had the Federal Trade Commission asserted its authority under Section 5?
Federal Trade Commission had put its toe in the water. I think it brought its first, I may have this slightly wrong, but I think it brought its first cybersecurity based enforcement proceeding, I think in 2003, which sounds like ancient history today, but back then it was brand new. As some of you may know, the FTC basically enforces Section 5 of the FTC Act, and Section 5 of the FTC Act has two liability prongs, one based on deceptive trade practices and one based on unfair trade practices. Originally, the FTC focused its enforcement efforts on the theory that the target company had engaged in deceptive trade practices by misrepresenting, sort of along the lines you were saying, Brian, misrepresenting something about their data security or something about the incident in question, and thereby deceived consumers in a way that created deception-based liability under Section 5. But around this time was when the FTC first came up with a theory of data security practices being, I guess I would call it, independently unfair for Section 5 purposes, even and regardless of whether the company in question had in any way done something deceptive in regard to those practices. So if the practices themselves were either deficient or inadequate in a certain way, the FTC would try to impose liability based on the practices themselves, as opposed to what the company said or didn't say about those practices. If you see the distinction I'm drawing there.
Yeah, and thanks for that clarifying. And so what we've seen in this field is consumer protection, both at the state and federal level, has emerged as one of the major areas of regulatory activity. At the state level, there are consumer protection laws that state attorneys general enforce. And then, I guess not so recently anymore, but increasingly, we've now bespoke laws, data privacy laws, and some that either have data security, cybersecurity elements to them, and then in some cases, actually specific cybersecurity laws that create either obligations or, in Ohio's case, purportedly an incentive. So, I mean, the field really has, I mean, it really has emerged in that time, going back to 2003 with the FTC, and certainly, you know, you've been in here all along the way. Before we turn to your class, just what are the major developments, would you say, in the field that you've seen, you know, across this arc of nearly 20 years?
Well, again, the themes have remained the same. Whether it's a regulator trying to enforce some statute that it has enforcement authority over, or a class action plaintiff's lawyer trying to bring a class action. What we saw then and we see now are the same combination of themes. Number one, sort of as I just mentioned, the security was not at an appropriate level. Number two, the company deceived the consumers or the class in regard to data security. And number three, regardless of the first 2 points, the company didn't give appropriate notice of the event once it became aware of the event. So inadequate security, deceptive security statements, or delayed notification are the three themes we continue to see in the cases. But the approaches for attacking or creating liability based on those themes have developed significantly. So, for example, Brian, just as an example, you mentioned state consumer protection statutes. Both from a regulator's perspective and from a plaintiff's class action lawyer perspective, because the state statutes often create an ability for a plaintiff to use the state consumer protection statute as a basis for a class action. We've seen the theories of liability expand there significantly, and also the theories of injury expand significantly. So, for example, currently, from a class action perspective, there's increasing use of the theory that you sort of alluded to, Brian, of loss of benefit of the bargain, where someone will say, "Hey, Marriott had a huge breach. Hey, Marriott, you promised me this level of security. You delivered only this level of security for my personal information, like the credit card I used when I made my reservation. And I therefore overpaid, and everybody overpaid for their hotel room by the difference in value between the hotel room with the security that you promised and with the security that you actually delivered." So that increment, whatever it might be, would be a measure of damage that everybody in the class suffered in terms of the overpayment that occurred in regard to their hotel room. That theory is currently very much in vogue and very much in the process of being tested in the courts. As you can imagine, one of the tests that gets advanced towards this theory is, how the hell do you ever possibly quantify what that incremental value was or is that was supposedly lost? But not surprisingly, there's experts who are prepared to testify that they can, in fact, calculate that incremental value. So you can see that this illustrates the level of sophistication to which the field has come compared back in the, I guess I would call it the old days, where the injury that was being complained about would be something like, well, I had to spend an hour of my time getting my credit card replaced, and therefore my injury is the value of my lost time. Much
or the
different
prospect,
kind of
the increased risk of identity theft and
right,
some more.
Yeah. One of the big challenges in the field is in regard to injury and remains that many of the injuries that are alleged to flow from a data breach are intangible in nature and therefore very hard to quantify, or if they're economic in nature, like the lost benefit of the bargain that I was talking about earlier, still very hard to quantify if they exist at all. So, but the current state of play in the field is that the plaintiffs bar is having increasing success in pushing these theories forward and getting cases through motions to dismiss and motions for summary judgment and class certification on theories like that. So the law, I'd say, currently is not at all clear as to how it's going to come down in terms of whether it's going to let cases be based on these theories of what I guess I would call either intangible injury or speculative economic injury.
And means it's not going away, right?
Yeah, I mean, contrary to my prediction back in 2008 and whenever it was to my firm management, data breaches have continued to happen and are happening at an increasing rate every year, both in terms of the number of events and the magnitude of the events in terms of the number of people whose information is involved in the events. So the area is really booming, and you've seen a flood of plaintiffs' lawyers into the area. You've seen a flood of defense lawyers into the area. You've seen that flood of forensic firms that I talked about earlier into the area. But the fact that that flood keeps occurring, both from a lawyer point of view and a forensic firm point of view, kind of illustrates that even notwithstanding that flood, the area has grown enough to, I guess, soak up that flood, if you see what I mean.
Well, and expand, right, in ways that are connected to, but don't directly necessarily relate to the prospect of civil litigation. The massive increase in formal regulatory obligations in the form of state laws, and even at the federal level, either increased regulatory activity based on existing authorities or new authorities emerging. And that's one of the things that I'll talk about when we get to the curriculum here is we try to give you that 360-degree view of, hey, security is at bottom a technical set of concerns, but they are driven really, really strongly by formal legal obligations or legal risks. And then, of course, data privacy is both a mix of technical and policy and a variety of things. So, all right. So with that, let's turn to teaching. So why did you want to start teaching? I mean, I have a strong sense. I wanted to make it my career, so I did. I think teaching's just inherently valuable. But in your head, what made you think, okay, now I got a little bit more time, I want to start teaching?
Well, yeah, I think I'd gotten to the point where I was, notwithstanding my incredibly youthful appearance, I'm actually well past my 65th birthday. In fact, my 70th birthday is next week. So I got to the point because of that I was ready to retire from private practice. But as you can probably tell from this conversation, I'm extremely interested in the field. And what I've always liked best about the work that I was doing in the privacy and cybersecurity space was thinking about the numerous different legal issues that arise, number one, and developing what I hoped were persuasive arguments about what the right resolution to those legal resolutions would be from a pure legal perspective and from a policy perspective as well. And so I really was interested in finding a way to kind of keep myself involved in the practice in some way, in the practice area in some way. And the teaching opportunity that Brian and Cleveland State were kind enough to extend to me seemed like it might enable me to do that. So I said, well, let's give it a try. And it really came through for me in terms of what I was trying to achieve for myself brilliantly, in that I had a tremendously fun time kind of putting the course together. And while I knew a lot of cybersecurity law from my private practice experience, I didn't know it all. So there was various pieces of the course that I kind of needed to teach myself. And I got to, both in terms of putting the course together and then in terms of doing legal research and working on some law review articles that I put together, including one that I wound up co-authoring with one of my students in the first semester that I taught this at Cleveland State. Really had a great time doing that. So I guess I'd have to let the students that I've had speak for themselves in regard to what they get out of the course. But in terms of what I was trying to get out of the experience, staying in the practice area, getting to kind of debate the legal issues with the students in the class, which is what the class is largely about, and helping the students understand what's going on in the area, legally speaking, has been quite rewarding and a lot of fun for me.
Yeah, and it was a small class, but I know all the students in it really enjoyed it. And it's one of the strengths of this program, both on the JD side and on the Master of Legal Studies side, is most of our profs, actually all right now, well, we just hired a woman who's expert in AI. So in terms of the broader field, we're expanding, but most of them are working professionals who, are just interested in sharing their expertise, but also, like you, not just, purely from a tactical, practical perspective, but in a way that allows them to get into some of these really interesting issues around how should we be, structuring this set of activities in society, right? In terms of who has obligations, who doesn't, what are those, and should there be liability that accompanies them? So it's certainly been a lot of fun for me to work with folks like you, because and as you say, teaching something gives you an opportunity really to figure out, okay, there's lots of stuff that I kind of know, but and I
Right.
know is there, but I didn't have to answer student questions about them, which
Yeah,
can really, yeah.
and also trying to kind of make sure I keep up with the field
Yeah,
as
right,
well,
right.
because new cases and new decisions are coming down literally daily in
Right.
this space, and the law is very much in flux and undecided and unresolved in the space on almost every issue of importance. And so I feel it's incumbent on me, if I'm going to actually do this, to be at least up to date in what I'm laying out for the students in regard to the current state of the law in the area, which means I need to keep up to date in terms of the cases that are coming down, which is something I wanted to do anyway. So it really was a kind of a win-win for me in regard to kind of staying part of the practice area on a going forward basis, even though I'd retired from private practice.
Yeah, and that's a great point. I mean, this field, unlike many areas of law, really is incredibly dynamic and evolving, both in terms of judicial decisions and laws, right? We're getting lots, not daily necessarily, but certainly lots and lots of new things. And when you expand the scope to think about technology law generally, and in particular artificial intelligence, which tends to land in the privacy space, or at least land connected to it, it's just you will never run out of work in this space.
Right.
All right, so before we let you go, just tell us just a little, give us a thumbnail sketch. What do you cover in the course, and why is that important? I mean, I think it'll be obvious from our earlier conversation, but
so the course is really it focuses on cybersecurity litigation, but it's broken down into what I think of as the two components that are kind of most important from a cybersecurity litigation perspective. One being regulatory enforcement that derives out of cybersecurity events and seeks to impose liability on companies from a regulatory perspective on cybersecurity events. And then the second half of the course is really focusing on class action litigation that comes out of cybersecurity events. So those are the two components, or that's sort of the structure of the course. And so on the regulatory side, we look first at the FTC, because the FTC, almost more than what it itself does by way of enforcement, but more from a thought leader perspective, is the dominant regulator, in fact, the dominant thinker in the space in regard to cybersecurity liability. And the FTC's thinking about what should be the basis for cybersecurity liability has really flowed through not just to other regulators, but also to the class action plaintiffs' lawyers who have taken the FTC's thinking and grafted it over to their cases. And also, you mentioned earlier, Brian, state legislatures, in terms of enacting the statutes that you talked about, have taken the FTC's thinking and sort of tried to codify it in terms of state statutes. So we start with the FTC largely for that reason, because if I'm able to communicate to the students how the FTC thinks about cybersecurity events in terms of when a company should be liable for a cybersecurity event, the students are then going to learn basically how everybody thinks about cybersecurity events. So that's kind of the undergirding for not just the whole regulatory section of the course, but the whole course, the whole entirety of the course. And the idea of the course is that if you're going to have or interested in having a career as a lawyer in privacy and cybersecurity, it gets you familiar with the litigation side of that from a cybersecurity perspective. But also many of the issues that arise in cybersecurity litigation are issues that spill over not just to privacy litigation, but also to all types of litigation,
Yeah.
whether it's, no matter what the class action is in question, it can be the issues of whether a class should be certified, for example. The same sort of issues we deal with in cybersecurity litigation crop up in other sorts of class action litigation as well. So it's targeted at folks like that as well. And then there are non-lawyers who have joined the course both this semester and last semester. And I think it's very valuable to them because the technical people in the field will have a view or a way of thinking about what constitutes reasonable security or appropriate security from a technical perspective. It helps them understand how that issue is thought about legally, and that informs their thinking about it from a technical perspective. But also, those folks who've been in the class have added huge value to the law students in the class and the lawyers in the class because they help me illustrate how disconnected the legal test for appropriate cybersecurity is from the reality of cybersecurity. And so, for example, in one of my classes, we talk about some of the legal tests that have been advanced by lawyers and legal thinkers about what constitutes reasonable and appropriate cybersecurity. And so we go through that whole test, and then I'll ask one of the people with a purely technical background, well, okay, how would you ever actually do that, if, in your field? And I ask that question with great confidence because it's always come back where the student will say, well, it's impossible. You could never do that in real life. And that's kind of drives home the point that there's this huge disconnect between what the law is saying reasonable security is and what reality on the ground says about that. So it's great when I'm able to, in the class, have a non-lawyer who's got the technical sort of background be part of the class, because I think on the one hand, they can add huge value to the class as a whole, but on the other hand, they get huge value out of it to understand how lawyers think about this issue and how, in their view, absurd it is how lawyers think about this issue.
And maybe with a slightly softer emphasis on the absurdity part, but that is the raison d'etre of both the JD certificate we have and the fact that it has technical aspects, and this program, which is designed to get folks who are in compliance, technology, and law thinking about, okay, how do you do that translation? And the reality that it's a risk call in many circumstances where you're just trying to navigate that disconnect, right? Between what might end up being the arguments put forth at the level of litigation or regulatory investigation and the realities of how do you manage the technical infrastructure. And when it comes to data privacy, obviously the broader compliance activities that you've got to engage in. And just the reality that law is driving a lot of this, even when law might not be fully connected to the reality on the ground. You got to figure out some way to do something that gets at least arguably close.
Yeah, from a technical perspective, I mean, it's basically impossible, because every technical person will tell you, well, there's no way to guarantee against a data security breach. You can, no matter how much money you spend on data security, you can't guarantee that there won't be a breach. So then the question becomes, well, that being the case, how do I know as a technical person when I have done enough? Recognizing that no matter what I do, I can't do enough in the sense of guaranteeing data security. So how do I know when I've done enough and when the residual risk that remains, no matter what I've done, is okay? Very, very hard question to answer. The technical people often say, well, just tell me. You tell me,
Right.
the lawyer.
You tell me. And the answer is I can't.
Yeah. Yeah. The lawyer says, well, no, you tell me, to the technical person. So
And you land somewhere in the middle.
it's a very,
Well,
very
listen, Doug,
difficult.
yeah, this has been great. I want to just give our attendees an opportunity. Any questions for Doug before we thank him and move on to some of the practical information about the curriculum in the program? Okay, well, feel free to jump in as we move forward with this. But Doug, I really want to thank you. It really is, we're really lucky. It's what I tell students, to have you teaching for us with the kind of expertise you have. Appreciate you taking the time today. But it's illustrative of the really great talent we've got from professionals who are doing it functionally pro bono based on the rates that we pay versus practice rates. So really appreciate it.
Well, I would say I'm the lucky one, not not you guys, but maybe it's a win-win of some sort.
I
But
think
I
it's a
certainly
win-win.
I
Absolutely.
think I certainly
Absolutely.
feel very, very lucky to be part of the team here and be able to do that.
All right. Well, thanks again, Doug, and we'll talk soon.
Okay, I'll sign off. And again, thanks for letting me participate in this.
Yeah.
Thank you,
a lot of fun.
Doug.
Thank you, Julie. Thank you, Brian.
Bye.
Bye now.
Well, Brian, with the interest of time, do you want to go over the curriculum quickly? I think that's a good
Yeah,
segue.
let's move to the curriculum, and I'll give that quick overview.
Great.
And yeah, and so Doug's class is an example of the fact that we have a structured program with courses that we offer in fully asynchronous format, but we also have a rich array of electives, some of which are in asynchronous and some of which are synchronous. And by the way, even our asynchronous courses always have live sessions in them. We really have a really deep and robust program. But the core for this program, as came out in the discussion with Doug, focuses on the legal aspects of cybersecurity and data privacy, but also blends in a solid grounding in the technical aspects for people who don't have a technical background. So even you don't have to have a technical background by any means. You certainly don't have to have a legal background. We try to give you some of both and a really deep dive into the legal compliance and business side of things. And so Introduction to American Law is the foundational law course, which I created and teach. That, along with legal writing, really are analogs to courses you would take as a first-year law student, although Introduction to American Law is a survey of most of the major legal topics that you'll encounter as a cybersecurity and data privacy professional, and uses materials that you would encounter as a first-year law student to get you up to speed into how to navigate legal analysis in these different areas. And then legal writing augments that and goes deeper into the use, research around, and to some extent, production of legal materials, so that you can become familiar with reading laws, reading regulations, and talking to lawyers, which is part of, as Doug mentioned, one of the real challenges in this space is trying to do that translation, because at every dimension, compliance specialists and technologists have to either indirectly or directly work with the legal side. And so then on the technical side, Cybersecurity 1 is the foundational course. Really gets you up to speed. It's a little bit of a deep dive, involves some hands-on labs. And then Cybersecurity 2, we call them 1 and 2, and in their original configuration, they were really tightly connected courses. But in this program, they really do separate things. So you don't have to do Cybersecurity 1 before Cybersecurity 2. Cybersecurity 2 gets a little bit more into the policy side of cybersecurity. And then Privacy Law and Management on the legal side is the survey of all the major US laws and to some extent European laws. And then Corporate Compliance 1 and 2 also are paired courses that you can take in either order. Cybersecurity and data privacy sits within the compliance operation in most organizations, in fact, in all organizations, at least to some degree. And so understanding broadly how a compliance program works is important, and those courses give you that. HIPAA and privacy. HIPAA is the major federal healthcare law that has both cybersecurity and data privacy dimensions to it. It's still, to date, one of the most comprehensive laws, and so a deep dive into that gives you the ability to navigate really any complex regulatory environment. And then cyber law is taught by another one of our really distinguished professionals, a former member of the Air Force Cyber Command, now a prof at the U.S. Air Force Academy. And that gets into the criminal law, national security, and to some extent, international law dimensions of cybersecurity. And then the technical capstone rounds out our technical offerings. You use, again, labs on the cyber range and lightly maps to the certified ethical hacking course. And also the prof there, who's really functionally my co-director, Spence Witten, who teaches Cybersecurity 1 as well, gets into some of the aspects of career development, resume advice, and things like that. And so with that, yeah, Julia, I'll give it back to you. And I'm going to apologize. I have to step out. I have another meeting I have to get to across campus before 1 o'clock. But I want to thank everybody for joining this call, and I will be happy to follow up by email or set up a Zoom meeting to talk to anybody about the program.
Thank you, Brian. I'll make sure that they have your contact information. You might want to make me a host. I don't know.
I did.
Okay, okay, just making sure. And if we get disconnected, here real quick, you can take a snapshot of that before I go through the.
All right, I confirmed it. You're the host, Julie. Thanks a lot, everybody.
Perfect. Thank you so much, Brian. This was such a great conversation today. Real quick before you all head out, if you are interested in this program, we just wanted you to be aware of our next application deadline and how to apply. So the good news is, if you are interested, you have plenty of time to apply for our fall 2025 semester, which doesn't begin until the beginning of September after Labor Day. The deadline for that application is August 1st. And we try to keep our application as simple as possible for students. So in order to apply, you will go to onlinelaw.csuohio.edu, and you will click on, I believe on the right-hand side, there's a big green Apply Now button. If you click on that, it'll prompt you to create an account. And then from there, it'll take you from page to page on how to apply. We look for a completed resume, a personal statement, and transcripts from your undergraduate degree. If you are worried about your GPA from undergrad, we can have a separate talk about what we look for. We take into account work experience. So always talk to us if you're concerned about any aspect of your application. But as I mentioned, the deadline is August 1st for a September 2nd start. Any questions about the application process or any questions in general? Unfortunately, if you have any questions for Doug or Brian, I might not be able to answer that, but I'd be happy to get their contact information for you. It is important to note that this MLS online email address goes to both Brian and I directly. So if you have a question more substantive for him, you could put in the subject line email for Brian. Any questions about the application process or the program in general, I will typically answer that, but Brian and I look at all the emails and work very closely together. But if there are no questions, I will conclude this webinar, and thank you all so much for meeting with us today. And if you're interested in the program, I really hope that we talk in the near future. But have a great rest of your day, and thank you so much again. Bye-bye.